Greetings, everyone, and welcome to We Are ACEDS, streaming live on LinkedIn, Twitter, Facebook, and YouTube. My name is Mike Quartararo. I'm the president of ACEDS. Today, we are going to be joined shortly by Merril Hirsh and Kassi Burns, two attorneys working in the legal space. Merril has a storied career, a law firm partner, and now runs his own firm, and is also executive director of the Academy of Court-Appointed Neutrals, also known as ACEN, which we'll get into in a minute. And Kassi, of course, is an attorney for more than 20 years, probably 15 of which have been spent in legal tech and e-discovery and AI. We brought them together today because I think that everybody thinks about e-discovery as this unique feature of like courtroom litigation, two parties have a dispute. And it's been my experience from my days in big law that, you know, proceedings like arbitrations and other sort of not so courtroom centric proceedings can also be a fountain of e-discovery issues and processes. And so we thought it would be really useful to explore some of the questions around alternative dispute resolution, e-discovery, how they relate, bring ACAN into the mix, and figure out how all this fits together in the e-discovery puzzle, for lack of a better metaphor. So let's get into it. Kassi, Merril, thank you for making time. Thank you for joining us today.
Thank you.
Thanks so much.
So let's start. I always like to start with a little bit about who we're talking to. So Merril, let's start with you. Tell us a little bit about who you are, what you do, and how you found yourself in the legal industry.
Sure. Thanks, Mike. Well, I am the executive chief bottle washer of the law office of Merril Hirsh and HirshADR. I've been a litigator for over 40 years and have actually handled cases in over 40 states. And after going with the government and then law firms, went on my own a few years ago. And since 2021, I've been the executive director of the Academy of Court-Appointed Neutrals, which is the professional organization of people courts bring in to help.
Appreciate that. Thanks, Merril. Kassi, who are you? What do you do?
Wow, existential crisis question right there. Thanks, Mike. I am Kassi Burns. I'm an attorney with King & Spalding, and I've been an attorney more like 15, 18 years. So I started out not in e-discovery, but as an in-house counsel for a franchise company, was very focused on copyright, trademark. That's really what I wanted to practice. But as so many of our e-discovery colleagues fell into e-discovery and really enjoyed the technology aspect of it and just continued on that path.
Fantastic. Thank you so much. Thanks again, both of you, for being here. Merril, let's dive in a little bit because I think some of our listeners today may be wondering what's a court-appointed neutral and how do they differ from what I guess we'd more traditionally call in the past, special master, and we'll talk about what that means. But what is a court-appointed neutral, Merril?
Well, a court-appointed neutral is what many people call a special master, only we're trying to change that. In part because master is such a horrible name to name somebody who was appointed by a court with some measure of authority, but also because it's such a terrible description of the job. Basically, think of it as someone a court brings in to help, like a Swiss Army knife is the best way to think about it. The most common examples could be somebody, the judge, pulling his or her hair out in frustration at the parties and saying, I'm sick of you arguing over discovery. I'm done with this. I'm going to send you to your mother. I mean, a court-appointed neutral. Okay. But it could be someone brought in to monitor a decree to see if people are following it. Or it could be a forensic accountant brought in to figure out where money went from a trust. Or it could be somebody who's brought in as an expert to help the judge figure out what's junk science when the judge is considering experts, or in this setting, in particular, someone with e-discovery expertise who might be an adjudicative or quasi-adjudicative role, helping work through motions on it, but it could be go down, facilitate, talk with the parties, help them do this less expensively, cut through this and save money and time, and take advantage of the fact that you have a specialized Not every judge does. So it can be used in dozens of settings, and the idea is to make justice more effective and efficient.
You know, I'm struck by the note, and anybody who sort of remotely follows the news has probably heard the word special counsel in recent years. Is it different? Like, is that a different appointment than a
Yeah.
court appointed neutral?
A special counsel is somebody appointed to be a lawyer to usually to prosecute something, on behalf of the government. A neutral is a neutral. Okay. They don't, when a court appointed neutral is brought in, they are brought in to be neutral, and not to represent one side or the other, and to help the mechanism of justice. And it can be used in other settings. It can be used in an arbitration too, and can be used in government settings and other things. But the most common examples are from courts.
And Merril, I have to put on my project management hat for a minute, because anybody who knows me knows that this is a big deal for me. It sounds like a court-appointed neutral is a project manager, a neutral project manager, but one who's sort of ironing out issues, or maybe one intractable issue, or at the end of the day, I'll use the word problem solver.
Problem solver is a great way of describing it. And it could be one of the difficulties in just getting across how useful this tool is that it has so many different facets to it. So yeah, it could be just brought in to help, what do you think about these motions? Well, look at this. They're saying these documents are privileged. Are they? What do these documents do? So it could be adjudicated, but it could be facilitative, help the parties work out this problem. Or it could be advisory, like what's going on here? There's this case about conditions in this jail. Go to the jail and do a report on it. Investigative. It could advise the court on scientific things or technical things. All right. So the plaintiff says they can search all of this really easily. The defendant says it can't be done. Who's right? And what could be done? That kind of thing. It could be as a liaison that insulates the court. The parties are talking about discovery. The judge doesn't want to know what they're saying about discovery, but the parties come out with, if the judge just decided this one motion, but not the rest of them, it would really help us resolve this. So who conveys that message to the judge while keeping the judge separate from the discovery process? Or who deals with the sort of things that judges can't touch, like the plaintiffs or lawyers can't get along with each other, or the defendant's lawyers can't get along with each other. The judge can't walk in the middle of that. So somebody brought in to help them work it out while keeping the judge from being able to be judicial, wear the robe, and be separate from this. Or any other, it is basically limited by your imagination as to what would help.
That's really helpful. So you mentioned the phrase special master. What is sort of behind the move away from that phrase, and why?
Okay. Basically it's two things. Obviously master is a lousy term. Okay. That's certainly a part of it. Why should we in this day and age be using that term for someone appointed by a court? But also, look, term master conveys someone brought in to take over, and you're using it to describe a job that someone brought in to help. And honestly, as a branding marketing thing, for trying to increase people's awareness of this, diversify the profession, bring new people in it, make them energized and understand it, the truth is no one really likes having a master except maybe a St. Bernard, right? It's really a terrible marketing term to be used. And the thing is that if you want people to think more broadly about the profession, have a term that captures it. So the idea is that we went through dozens of possible terms, came up with court-appointed neutral as an accurate description that we're trying to coin. And it's not just, ACAN changed its name. We used to be the Academy of Court-Appointed Masters. So it isn't like everyone who's used the term master in history is evil or vile. That's our own organization. But we changed it. The ABA has done a resolution last August saying, yes, we ought to change this to court-appointed neutrals. So has the National Association of Women Judges, the American Judges Association, the National Council of Juvenile and Family Court Judges, the National Asian Pacific American Bar Association, and various other organizations have all said, you're right, we ought to change this term. And there's an effort to change it in the federal rules where it uses the term master in the federal rules for this role, and to get states to change it in a model rule that we're trying to get people to adopt.
Yeah, there's a lot of, I guess I'm proud to be part of an industry that at least takes a look at some of these anachronistic terms and figures out better ways, more representative ways. I think too that it also goes to the notion of respect for the judicial process and access to justice and those kinds of things, because if people hear these sort of old words, they think about it in a different way than if they hear the word neutral. It suggests something more friendly, if you will.
And
okay, great.
More friendly. It's really what it should be. It's understandable why someone would be petrified about having a master appointed.
Right. Kassi, thoughts on this? You've been quiet.
Yeah, I mean, I've only been a member of ACAM for probably 2 years, Merril, and it came about because I was curious about what other attorneys were doing, what other law firms were doing, and saw that there were some discrete, niche law firms very focused on e-discovery, and they would have on their law firm page that they're a member of, at the time, ACAM, and so I just started pulling that thread and thought, well, what is this? Is this something I want to be part of? And it just happened to be at the time when ACAM was talking about not only changing the name, but also putting a very focused, intentional effort into expanding the membership to help diversify the pool of court-appointed neutrals available to the judiciary. Because what tends to happen, based off of what I've heard from people, is a judge may appoint someone that they already know, and I know as someone who I've been in the weeds in e-discovery, and if a court-appointed neutral is appointed for an e-discovery thing, I want it to be the best and the brightest, because it does have implication in potential case law. And not saying that I'm the best or brightest. I'm as much motivated to be a member to get other people that I think are brilliant out there in e-discovery, working very hard and diligently to be aware of this and consider it as something that they may want to do. So, and again, it's not anything about existing court-appointed neutrals. I think we're better by having a more diversified pool, especially knowing in the context of e-discovery, a lot of the issues we're dealing with from the past 2 years and onward, it's increasingly challenging, more technically difficult data sources, and really wanting to prime the field so we get more people out there aware that it's something that they could be involved in, and really trying to advocate and be a cheerleader in essence for the organization and my colleagues. I just think it's a great opportunity, and I just never at e-discovery events heard people talk about how you become one. What's that process? And I would love to, ACEDS, luckily you all have been very open-minded about collaborating with us. And I think, maybe this is a great starting point to have broader discussions about what we can do to encourage more people to consider this as an option in their career.
And you reminded me of a very, I think, important question for our listeners, and that is, and I'll direct it to Merril first, but Kassi, you can certainly comment. Does a court-appointed neutral need to be a lawyer? Is it like a sort of expert witness? Not always a lawyer, could be like an accountant or construction expert. Do you have to be a lawyer to be a court-appointed neutral?
You don't have to be a lawyer. Some of the things a court-appointed neutral might do, you probably would want a lawyer, but others you probably don't want a lawyer. And certainly if you're talking about e-discovery, somebody who has common sense, which is one uncommon thing in the world, but probably the most important qualification for the job, but also the expertise to help people work through this stuff may be absolutely the best choice for it.
Kassi, thoughts?
I completely agree. And actually, Jerry Bowie is a member. We both joined at the same time, and he is not an attorney. He's a forensic expert. And that's a perfect example of someone who would be, a forensic expert who would be a great resource for the judiciary, especially as we start dealing with how the impact of AI, generative AI, is going to impact the courts. They may use court-appointed neutrals as an a resource for the courts. So I think we'll likely potentially see the need for more people like that. In addition to, I believe, e-discovery issues are going to increasingly become a challenging new piece to litigation.
And then just one more follow-up. How does one sort of present themselves as available to be a court-appointed neutral? Merril?
Do you want to start, Kassi? Why don't you?
Yeah, I will start. I mean, I think some of it's historically, maybe, and Merril can maybe correct me, is making yourself known to maybe local judges that you would be available. So something I've been doing is I am an introvert. People don't believe me, but I tend to be like Gollum, and I kind of hide in my cave. I work from home, and it can be hard for me to get out and network, in my local legal community. So I have made a very intentional effort to get involved in my local bar association, not the Dallas, but Tarrant County, because I am in Fort Worth. But I mean, right after this, I'm going to go and give a presentation to the Tarrant County court staff on generative AI and legal ethics. So I think it's really not just rolling in for me. It's a longer game. I really just want to establish myself in my community and be seen as a resource generally, whether it's offering CLEs to the local bar association. And I think building up that credibility and also talking about not only e-discovery issues or AI issues, but also the role of court-appointed neutrals. So for me, it's a little bit of a longer game, and some of it, quite frank, is I have a busy day, so it's not something that I'm doing as my primary goal. From this is what I want to do day in, day out. I want it to be 50% of my work. It's really something I want to do in my free time because I do feel like it's something I'm very passionate about. So that's the route I'm taking. I could probably maybe escalate it by having more direct reach outs, but that's just what's working with me and my workload balance and also my personality. But I'd love to hear, Merril, other perspectives on how people may get themselves appointed.
Well, all right. Let me put it this way. The most important thing we're working on, which means it's a work in progress, is to create pathways that didn't previously exist into the profession, which is tricky. I mean, it's not only tricky to build a plane while we're flying it, it also means that you can't say, oh, here's a guaranteed way to work. No one's tried it before, but trust me on this one, right? So historically, the easiest way to get appointed is to have a friend who's a judge, okay? And that's bad, all right? It's not bad that judges have friends, and some of their friends are terrific at this, but that shouldn't be the only or primary way because it guarantees that you have repeat players. It makes it very hard for new people to come in. You don't develop it. So how do you go about developing it? One is we instituted an incubator program so that we could provide not just training, but mentoring and pairing members with mentors. Our website, people post profiles so that someone looking for a neutral can find the person on our website. We also have an RFP process so that if people want to just put up an RFP, we send it out to our members so they can respond to it. We also try to publicize people consciously on social media. We publicize if they're doing something. We post stuff there. We have our people repost it to get people out there. We're trying to establish different best practices for the selection of it. So we spend a lot of time talking with a lot of organizations and judges, and we say, look, if you're going to appoint a neutral, don't just go and appoint someone you already know. And if you're going to ask the parties to give you a name, don't just say come back with one. Have them come back with a Ray corollary compliant list of a diverse group of people to choose from, and also have them tell you where they looked. So how wide a net they've cast, so it isn't just the repeat players. Plus, if you want to do one step better than that, set up a roster, which will get people to understand the job, get it vetted more effectively. And the Indiana Commercial Court just set up a roster of court-appointed neutrals. They've gone through that process and done it. And those people aren't all repeat players. They aren't all people who've done this before, and they've been vetted so they're better accepted, by the bar. Now, go back to our members and say, look, we'd like to set up rosters in other places besides Indiana, right? So Tarrant County, like where Kassi is, or some other place. How might you go about doing this? Could we do a program to talk about court-appointed neutrals, and then do some kind of roll up our sleeves thing, with the courts, with stakeholders, with everybody who's affected by this, and see if we can provide the resources to help set up a roster. And if you are involved in doing that process, you're in the ground floor of getting involved in this, because people know you through the process of setting up the roster and the process of talking about neutrals. So you've gotten the visibility. And one advantage of the profession itself is that the barrier to entry, the historic one, is a problem, but the actual skill set barrier to entry isn't that bad, because you can come at it from being a lawyer who knows about litigation, or being an e-discovery professional who knows a lot about e-discovery, or another type of tech professional, or you can already be an arbitrator and mediator and want to do this for courts. It's really at the intersection of a lot of skill sets, so you can get into it without necessarily going, oh, you have to do this and do that training and go through this, and 20 years later something might bloom.
I appreciate that. Lots of information, really helpful. But let's pivot a little bit to e-discovery. Kassi, I want to turn to you. How exactly, or do you have a particular case? Don't reveal any confidences, please. How exactly does e-discovery intersect with being a court-appointed neutral? What kind of issues have you dealt with in the past, or could a court-appointed neutral expect to be called upon specifically in e-discovery to deal with?
Right. And just to be clear, I've not been appointed yet. So, but based off of my understanding, I think many e-discovery professionals listening to this right now may think, what's the point if there's already a magistrate judge? And I think there's a significant court-appointed neutral can play in state courts. Often magistrate judges in federal court will handle a lot of the e-discovery disputes. Now, I think that there have been times where even magistrate judges have reached out to a court-appointed neutral because maybe a specific case is just so voluminous, so involved, it's taking up too much of their time. But, in the context of maybe a state court, I think it could be anything from things you would maybe normally see a magistrate judge help resolve. It could be, as I believe Merril alluded to earlier, they're going to look at the privilege documents. There's a privilege dispute, and they're going to be the ones making a determination, if the documents are actually privileged. So it could be anything like that related to technical issues. So I think thinking of a very basic level, what a magistrate sometimes does, and seeing that as a resource for state court judges, I think is a great maybe starting point. So, and I think, we always see the disputes often come from an ESI protocol, or maybe not an ESI protocol, and the parties disagree over the compliance with that, technical issues related to that. So I think that's the kind of engagement that likely could happen, or it could just be I think the point you raised earlier, Mike, about there's a lot of project management. I think we joke sometimes that this is a lot like cat herding, which is a phrase we're very fond of using in e-discovery, cat herding. So I think it's pushing that ball forward for the court in a way in a neutral capacity. So that's really where I see the e-discovery piece. And again, I do think that there's a potential for generative AI issues that are going to start rolling out. It could potentially be a great resource for, state court and federal court as well, for the judiciary as they start dealing with all of this.
And Kassi, are there particular skills that a court-appointed neutral should possess, or that you recommend they possess, either in anticipation of or actually being appointed?
I mean, I think being curious, being willing to maybe not be comfortable with where you are, because you would be doing something that's different than something you've done before. Being a good communicator. I will say I've attended now 2 or 3 annual conferences with ACAN, and ACAN membership tends to be a lot of mediators, ADR professionals, in addition to other niches like e-discovery. And the vibe that they bring, it's just in the level of engagement of how panels are coordinated, how when we were discussing the change of the name and the names to consider, just getting exposure to that non-adversarial, but very much bringing parties together, hearing all the voices, taking the time to listen to everyone, consider everything. For me, that was really great exposure because that's not necessarily what you get. A lot of times at e-discovery, it's kind of, people have a very strong position and strong opinion because we're used to defending our clients zealously, of course. So I think kind of stepping back and putting your brain in that headspace is very important.
That's really helpful. Merril, anything else? We're about out of time, but anything else you want to share about?
Since Kassi and Maribel forced me to wear this T-shirt, I do need to explain it. Okay,
it was the last thing I was going to ask you.
Gavaliers. This actually says Gavaliers. It is a gift from the president of the National Judicial College, Dennis Aldana, and this is a thoroughly fake sports team that they set up for the National Judicial College in Reno. And you can't see this, but there's a Latin stuff that I had to look up on the internet because people think once you're a lawyer, you automatically know Latin, but I don't know any Latin. But it says, if you think this is true, you are mistaken. So
it reminds me of all the Latin phrases I've forgotten. I appreciate that. But anything more you want to share about ACAN, its mission, and
Sure.
how we might advance the cause of the court-appointed neutral?
Well, one thing is, it really is easy to see about joining. You can go on our website, which is www.courtappointedneutrals.org, and there's a place to join. There we've set up memberships so that there's a category of membership for people who've done this before, but there's a category that we call member for people who are just interested in becoming a neutral.
Merril hung up a little bit,
or associates to work, who are interested in the profession and not necessarily becoming one. It's a great way to find out. We've got an awful lot of stuff on social media. Follow, ACAN, and a lot of things are happening. We're trying to really reform how our profession works, and that's exciting.
Appreciate that. Thank you very much. Kassi, what's going on? Anything new? Anything interesting? Any big events coming up? Speaking engagements?
Well, for me personally, I'm going to head to the Tarrant County Bar Association and give a presentation on generative AI and legal ethics. And, I have a few other AI-related speaking engagements. I will be at ILTA. So, but you know me, you don't have to ask me twice to talk about AI. So,
Okay. And finally, how should listeners get in touch if they want to contact you? Kassi?
LinkedIn would probably be best.
Merril?
Well, I'm on LinkedIn, or you can email me, Merril at merrilhirsh.com. It's super imaginative. MERRIL@MERRILHIRSH.com.
Appreciate it. Thank you very much. Thank you, Kassi. Thank you, Merril, for making time and talking with us today. Thank you, everyone, for joining us. If you are interested in our short form video interviews like this, you can find We Are ACEDS live streams in your LinkedIn, Twitter, and Facebook feeds, or check out our YouTube channel where you can watch previous interviews. Thank you so much for joining us today, everyone. And as always, be kind to one another.